Today, we will be covering trial techniques. After this video, you should be able to identify the 6 phases of trial, describe the jury selection process, and explain the paralegal's role at trial. There are 6 main phases of trial. Prior to trial, a jury is selected. The parties are then given time to make opening statements, call witnesses to testify and be cross-examined, and give closing arguments. The judge will also provide jury instructions to the jury on the applicable law. The jury will then deliberate and determine whether the plaintiff met his or her burden of proof when applying the law with the facts. All cases involving a jury begin with the process of selecting or seating the jury. The jury members are selected from a jury pool that has been gathered from among the local citizenry. Most jury pools are taken from the ranks of registered voters. Once a jury pool has been assembled to the courthouse, members of the pool are asked to fill out preliminary information forms, copies of which are given to the attorneys in the case. In federal court and Hawaii State Court, a civil trial uses 12 jurors. However, the parties are allowed to stipulate to fewer than 12 jurors if the parties so desire. Voir dire means to speak the truth and is a process by which the jurors are questioned to determine any bias they might have that would affect their ability to be fair and impartial in the case. Peremptory challenges are automatic eliminations of a potential juror by one side before trial without needing to state the reason for the elimination. Each side has the right to a certain number of peremptory challenges. Finally, attorneys may dismiss a juror based on cause due to a juror's bias. For example, in a trial, an attorney may want to know if any potential jurors are related to or are friends of the officers and employees of the defendant, or if any potential jurors has any financial interest in the outcome of the trial. If it is determined that the potential juror is biased, then the attorneys may dismiss the potential juror based on cause. The first step of the actual trial is the presentation of the opening statements. The objectives and scope of these statements are to provide the jury and judge with a summary of the case. An opening statement should be brief, use ordinary language, be interesting, and use appropriate body language. It should also appeal to the jury's sympathies and be presented in a tactful manner. A paralegal is instrumental in preparing witnesses for trial. During the presentation of evidence, this preparation pays off. The presentation of evidence can be divided into 2 stages, the case in chief and the rebuttal. During the case in chief, both sides present testimony and evidence they hope will convince the jury of the validity of their case. The plaintiff presents his evidence by calling witnesses to testify and placing those witnesses under direct examination. The defendant then has the right to conduct a cross-examination of each witness. The roles are then reversed, and the defendant places his or her witnesses on the stand for direct examination, and the plaintiff then has an opportunity to engage in cross-examination. At the end of the defendant's case in chief, the final steps is the presentation of the closing argument. The objective and scope of the closing argument is to summarize the evidence that has been presented in the plaintiff's and defendant's case in chief, and convince the jury that the attorney's interpretation of the evidence is the correct one. Each side will explain his or her theory of the case and will demonstrate how the evidence presented at trial supports that theory. Each attorney will also do her best to destroy the jury's belief in the credibility of the other side's witnesses. Because so much of the success of a jury trial depends on the closing argument, an attorney should take great care in drafting it. To be effective, a closing argument must be well planned and persuasive. The closing argument must organize all of the evidence presented into a coherent pattern that the jury can understand. The attorney may also attempt to point out the weaknesses in the other side's case. With respect to the jury instructions, the responsibility of giving the jury instructions belongs to the judge. Once instructions have been given to the jury members, they retire to consider the case and to decide on a verdict. The paralegal's role at trial involves the same general areas that the paralegal was involved in during the preparation stages. These areas of participation include witnesses, exhibits, note-taking, and general trial coordination of tasks. This concludes today's video on trial techniques. Please proceed with completing this week's activities.